Okay, hello everyone, and welcome to this my UPC aperitivo. As you probably are already aware of, the rules of the UPC aperitivo are quite straightforward. Each firm has 10 minutes to talk about the topic, and then there are 5 minutes left for question and answers. I do ask you if you can write down any questions which can raise after a specific topic. It is a UPC aperitivo, so we are drinking something, and we do hope that you are drinking something as well. Myself and Mr. Davide Rondano, we will talk about the motorcycle airbag case that we had the pleasure to handle together on behalf of Dainese. And the first part will be presented by Mr. Davide Rondano. So Davide, please go ahead. The floor is yours.
Okay, thank you. Thank you, Mario. Okay. Okay, so here you can see my presentation. Please confirm. Okay, just a brief summary of the case. As Mario said, we started an infringement action on behalf of Dainese against its competitors, Alpinestars Research, and some distributors, in particular a Spanish company, and we'll see the importance of this factor, before the Milan local division of the UPC. This was in August 2024. And initially, we claimed infringement of two Dainese patents, EP 117 and EP 364. All the defendants filed respective counterclaims for revocation against both of these patents. Then, following a decision, at that time, there was appeal proceedings pending against EP 117. Oral hearing before the Board of Appeal of the DPO were held in the early 2025. The patent was maintained in amended form, but in a very limited form. So we decided to waive our claims based on this patent because we could not claim any more infringement of this patent. So the action before the UPC continued based on EP 364 only. Oral hearing was held before the Milan local division in March, last March, and the final decision was that EP 364 is valid but not infringed. So here is a brief summary of EP 117. I would skip this slide because just some information about this patent, and as I said, this patent was the decision did not relate to this patent because we waived our claim based on it. Instead, what is important is EP 364, that, as you can see here in this image, relates to a protection device for the protection of user, in particular motorcycle. Is a protective device that is arranged in the chest area under the suit or the vest of the motorcycle. It comprises an inflatable member, so an airbag that in case of accident is inflated. This the airbag has a hand-comb shape with finger portion that are arranged within this inner housing formed in a containment structure that is made as a mesh structure. The function of this mesh structure is to contain the inflation of the airbag, but also to allow passage of air therethrough. This patent was granted in January 2024, validated as unitary patent and plus Spain and Great Britain. Alpinestars filed an opposition against this patent in October 2024. So after we issued them before the UPC court, the opposition division decision was issued in October 2025. The patent was maintained in amended form based on the combination of claims 1, 5 and 7 of the patent as granted. The decision was appealed, and appeal proceedings are still pending before the Board of Appeal of the EPO. So a first aspect to underline, to point out, is coordination between opposition proceedings before the EPO and the UPC action. As you can see, the opposition proceedings were very quick. In fact, they were accelerated due to the pending UPC action. The oral proceedings were held just 1 year after the filing of the opposition. The oral hearing before the Milan local division was not postponed, even though there are appeal proceedings pending. We and the defendants did not request postponement because otherwise, considering that the appeal proceedings will last until the end of this year or beginning next year, it would have taken too long to wait for the decision of the Board of Appeal of the EPO. Regarding validity, the defendants raised many attacks against this patent based on lack of clarity, insufficiency of disclosure, lack of novelty, and lack of inventive step. All these attacks were rejected. What is important is that regarding lack of inventive step, the court admitted at the oral hearing only the lack of inventive step attacks initially submitted with the statement of defense, even though we later amended the claim 1 as we had done before the opposition division of the EPO, because claim 1 was merely the combination of granted claims 1, 5, and 7. So the subject matter of this claim was already known at the outset of the proceedings. So admitting later attacks would have been against the front-loaded principle of the UPC. So even though the defendants, of course, tried to introduce at a later stage other attacks, all these attacks were rejected, and so only the three attacks raised initially were admitted at the oral hearing. These some pictures just to explain the infringing products. These are the products sold by Alpinestars. And regarding infringement, the court decided that there was no infringement because there was in the Alpinestars product no second region as set forth in claim 1. The second region is defined in claim 1 as a free region that in the deflated condition of the airbag is not occupied by the airbag. So it is a region within the inner housing of the mesh structure, which is free, so which is not occupied, and so allows passage of air. And the important thing is that even though we did not specify any size for the second region, so claim 1 simply states there is a second region that is not occupied by the inflatable member, the court found that in Alpinestars product, this region is, in their opinion, too small. In fact, it corresponds to 7.5% of the whole area of the mesh structure. And this amount was considered too low to consider the second region, to consider the free spaces in the Alpinestars product as corresponding to the second region within the meaning of claim. So for that reason, infringement was of this patent was denied. So now we can move on with Mario. So I leave you the word.
Thank you, Davide. So basically, I will concentrate my attention on the preliminary objection raised by defendant number 6, which performed the infringing activity both in Spain and within the UPC contracting member states. And I do believe it is very interesting, the position of the Milan local division. Basically, they recall all the rules and laws concerning the international jurisdiction of the UPC. So we can move on, and in particular, the UPC concentrate its attention on Article 8 of the Brussels regulation recast. Next slide, please. Where, and as you probably are aware of, Article 8 allows multiple defendants to be sued in the place where just one of them is domiciled, provided that there is a close connection between the companies and the cases, and there is a risk of irreconcilable judgments. And the analysis performed by the Milan local division was, in my opinion, very accurate. The court says that basically between the Alpinestars companies, the Italian companies, and the Spanish distributor, there was the same situation of fact, since the patent was more or less the same, infringed the European patent on one hand, and the Spanish portion of the European patent on the other hand, and the infringing activities performed by the companies, by the defendants, were identical. So they all sold these Tecker 3, Tecker 10 products. The same legal situation as well. In particular, a point that I do believe it is very interesting is the fact that the court, the UPC, admitted the possibility to apply the Spanish law, since the Spanish Patent Act and the UPC agreement are basically identical. And in particular, the Spanish Patent Act is based also on the EU legislation and on the enforcement directive. And I do believe this is a very interesting point. Furthermore, the UPC stressed the fact that the defendant 6, the Spanish defendant, could and should have foreseen the possibility of being sued together with the other companies, also before another court, due to the fact that the infringing activities were identical. So it could and should have foreseen such possibility. And last criteria was the abusive. Was it abusive or not? And basically, the court said that the fact that the defendant 6, the Spanish defendant, was sued before the Milan local division was not abusive at all. But, and these are my last slide since we almost ended our time, the court decided, so we can move on, Davide, thank you, decided that to stay the proceedings, the UPC proceedings, pending a nullity action, even if it was started only by one of these three defendants, and by defendant 1, so Alpinestars SPA, decided after the BSH, the CJEU decision, BSH against Electrolux, decided to start a nullity action of the Spanish portion of the European patent before the Spanish National Court. And since there was these, and there is these proceedings pending, the UPC decided to have jurisdiction, but to stay the proceedings, given the fact, and this is my last slide, given the fact that the Spanish court does have exclusive jurisdiction over the Spanish portion of the European patent according to Article 24. Next slide, Davide, please. So for the activity performed by all the defendants in Spain, the UPC prefer to stay the proceedings, also according to the discretion that the UPC agreement and the Rule 295 gives to the UPC on the possibility to stay the proceedings. So this is peculiar. We, of course, do not agree, because if this trend will be confirmed by the UPC, we could see the rise of a new, I say, Spanish torpedo, which sounds like the very well-known Italian torpedo, and I do not believe that the UPC should stay the proceedings, giving a nullity action pending in before a national court. But it will be interesting to see the developments. I don't know if we are on time.